Next talk is by Dr. Ashok Nataraj. He will be talking on medical legal litigations in ophthalmology with examples of case scenarios and discussions based on it.
Yeah. Thank you, Madam, Reena Madam, for this opportunity, and thank you, KSOS. So, the point regarding consent, as Dr. Mahesh was saying, it was a very important aspect because there are many situations where, without the knowledge of the patient, if there is no emergency, if you do something that is going to land you in big soup, even though you are doing for the benefit of the patient. Now, what I'm going to do here is, give you some real case scenarios, okay? And we'll have some discussion based on this case scenario so that, there is some information you get out of it. So this is a actual case where a 52-year-old gentleman develops sudden loss of vision in the left eye. And he comes to a clinic in India where he is diagnosed to have very low vision and he has got exudative retinal detachment. So he has got vitritis, all signs of inflammation. Angiogram shows a disc leak, and he was diagnosed to have an inflammatory exudative RD, VKH or uveal effusion syndrome or whatever. And other tests were all uveitis workup were all negative. Patient was started on steroids. So initially the patient responded, but after 2 or 3 weeks, the response was not adequate. For a second opinion, patient was sent to a higher center, and there a possibility of atypical CSR was made, and steroids were stopped. And again, patient was on follow-up, PDT was given, lasers was given, but the disease never improved. And finally, even though it was an exudative retinal detachment, patient underwent vitrectomy, endolaser, silicone oil injection, oil was removed, and in that eye, patient recovered 6/12 vision finally. And 6 months after that, the other eye also the same problem happened. So even in the higher center, everybody was in doubt. Nobody knew what was happening, and final diagnosis of uveal effusion syndrome was made, and scleral thinning surgeries, etc., was made. And the other eye patient did not regain full vision; he got only 6/60 vision. So the whole process lasted for around 6 to 7 years. And after 10 years of the incident, patient now has given a case in the National Commission claiming compensation of 13 crores from the doctors who saw him initially, because he says all this happened because the initial doctors gave him steroids and they are responsible for it. So this is a case scenario. Now, see, when a case like this comes, what are the things that go on in your mind? Now, if you see, we have the Consumer Protection Act of 1986, and now the new act has come, that is in 2019. Now, in the new act of 2019, medical profession has not been explicitly been mentioned. So, Mahesh sir, what do you feel like whether the new act encompasses medical negligence? The Consumer Protection Act of 2019, it is not expressly mentioned. Roll out. So that is not a, you cannot say that just because it is not mentioned, medical profession doesn't come under the act, because you give a service to somebody and you get a compensation. So that contract, whenever it is there, it comes under the Consumer Protection Act. Then there are something like, see, this case was filed 10 years after the cause of action started. Cause of action means the initiating incident which caused the whole damage started. So that is called as the cause of action. So the whole period is like it happened 10 years after that. So can a patient give a case like that? So actually the limitation period for consumer protection case is 2 years. But if the court feels that, the patient did not get an opportunity to file in those, if they can get a valid reason, this can be exempted. So you should not think that after 2 years, nobody can give a case against you. Even after 10 years, you can. And that is the importance of having proper documentation. My sir said at least 5 years you should keep. So suppose this patient is your patient and after 10 years he has given a case. You have destroyed all the documents after 5 years. What will you do? So I think it is better to preserve, at least in electronic form, all the documents for however long you can. Okay. Now, why this case was filed in the National Commission? They could have filed in the District Commission, no, or State Commission. Why? Because it depends on the amount. Okay. If it is less than 50 lakhs in the District Commission, 50 lakhs to 2 crores is the State Commission, and more than 2 crores, you have to file it in the National Commission. And actually, it depends on the amount of money the patient has spent on the treatment. That rule came only now, but initially it was the amount of compensation you were asking. So if the patient can show that he has spent 2 crores, more than 2 crores for the treatment, then he has to file it in the National Commission. Now,
So what is our probably all of them spend less than 1 lakh, no?
Yeah, it should come in the district commission only.
It cannot actually go to the
They
state.
cannot go. It depends on the amount of money you have, not the compensation you are asking.
Yeah.
The amount of money you are spending, that is the thing.
So even state commission, it cannot go directly.
No, after 50 lakhs, state commission. 50 lakhs to 2 crores is state commission.
Depending on the expenses of the patient.
Expense of the patient.
Cut-off?
That is what, like up to 50 lakhs,
Okay.
district commission.
Okay.
50 lakhs to 2 crores, state commission. More than 2 crores, national commission. And appeals will come. See, you go to the state commission, that is different. Going up and up, that is different. But initially, where you have to file the case initially, that depends on how much money you have spent. I mean, you have to show. Now, see, this patient, as we said, had multiple possibilities. It could be an inflammatory exudative RD, it could be a typical CSR. You have a differential diagnosis, but you cannot treat a differential diagnosis. No, you have to treat a diagnosis. Then only the patient will recover. So, does treating another differential diagnosis amount to medical negligence? What do you feel, Biju sir? Now, this patient had an exudative RD, multiple diagnosis. It could be anything, could be a typical CSR. I mean, and every possibility you have something to substantiate with also. So, you can only treat a diagnosis, you cannot treat a differential diagnosis. You have to go forward. So, does treating a possible differential diagnosis amount to medical negligence?
No, I don't think so.
Actually, if you have done the proper evaluation and tests and everything, the interpretation can differ from different doctors.
Yes.
So there is even what is that Batra Hospital versus Kusum Sharma. Supreme Court has clearly mentioned that different opinions on the same findings it is just like interpretation of the data of the lawyers.
And if you to put it forward, does error of judgment amount to negligence? Like a patient comes, you have sincerely seen the patient, but in your opinion, you felt at the time it was that, and you have treated. It is not that you have not attended. So that is called as an error of judgment. So do you think error of judgment comes under negligence?
No.
So that is, yeah, correct.
And reasonable skill from the,
yes.
that is all expected.
Now, the point is, patient, whatever negligence says is reasonable care. That is all. By which is exercised by an ordinary person in that particular position. An ordinary physician of ordinary skill. That is all that is expected. So that is the important thing. So even error of judgment is not negligence. That is the most important point. Then we have certain tests called Bolam's test, Bolito's test and all that. Now, what it says is, whether you have done something, whether it's right or wrong, how will you measure? See, you've done some treatment and it goes to the court. Now the court has to decide whether what you have done is right or wrong. They are not medical professionals, no? How will they know that what you have done is the other party will say it is wrong. You will say you're right. So this is the two tests that we do, that is Bolam's and Bolito's. Bolam test is like, see, suppose a similar person, another doctor in the same situation, if the court feels he also would have done the same thing, then what you've done is correct. Okay. But the problem is the doctor whom you are calling for this expert witness, he is your friend. Whatever you say, he will say, yes, I will also do the same thing. I will also do. That is possible, no? Because you belong to the same profession, you can fudge it. So now the courts are moving into something called as Bolito's test, where it is not only required that a doctor should substantiate, it should be substantiated by documentary evidence like literature or, journal reviews, etc., which can really show that what you have done is right. So hard evidence or documentary evidence or journal evidence plus what you've done is correct. That is called as Bolito's test. Now, the legal thing is moving towards from Bolam's test to Bolito's test. So, if you've done something like this, the doctor should take a medical review, say that, see, the set of 100 cases, there is a review where this treatment is the treatment. So, you can substantiate it. So, that is one thing. Now, how can I prove that I am right? So, in this particular case, you see, the final diagnosis was uveal effusion syndrome, okay, and nobody knows what the diagnosis is exactly. So what you can say is treating a differential diagnosis is not a crime. Whatever is possible, you can do, and you should bring out journal review saying that in uveal effusion syndrome or inflammatory exudative RDs, steroid is the treatment of choice, and you have not done anything wrong. Now another thing is like there is a saying that no, can I take an expert opinion? Now you can approach the court and say this is a very complicated case. Now the court cannot, so many people will be saying, let us constitute a medical board of experts from some big hospital and let them decide on the case. The point is, the court will not agree to it on the face of it. If there is a gross wrong, the court will say, let us just examine the case and see how it is. Suppose the case is grossly wrong, like res ipsa liquitor, where you leave a scissors inside the patient's stomach and it is discovered. There is nothing to prove, no? If it is something very obvious, the court, you don't need a medical board. So getting an expert review or medical board is not a very easy thing. The court has to be convinced that this particular case requires a medical board, and then only you can get a medical board. Then how is the compensation calculated? It depends on, there's a saying in law which says that it is cheaper to maim than to kill. There is one saying in law. Because if you injure the patient, you have to pay for damages. If you kill the patient, it doesn't matter, I mean, don't take it to the face of it. That is the thing. So what happens is, if it's a young patient, like an ROP, that is the main thing. And they will calculate how much the person is going to earn if he had been working for so many years. And what was his earning capacity? So if you have a patient who has been earning 10 crores a month, and you had some negligence, and because of that he is not able to work, so from day 1 to 30 years, they will say 10 crores he is to earn every month. So like that, they will calculate the compensation, and you have to pay a huge compensation. So this is a basic thing. Now I'll say just one more small case also, a scenario. So this is a case of cluster endophthalmitis, and the patient has gone to court. Now I'll just show you an example how, the lawyers try to twist you. Now how do they get the whole thing to their side, even though you have done everything right and endophthalmitis is not in your control. Now they will ask you, how many years have you been performing cataract surgery? If you say 1 year, they'll say you are inexperienced. Okay. And second thing is, have you had similar complications? You would have had endo, no, before also. No, I'm just telling you. It is possible, no? Now if you say I've had endo, then you say, this doctor serum parivadiyanu endo. You understand what I mean? Okay. Then they will ask you, did you perform cataract surgery because you thought it was absolutely necessary? Now the patient has 6/12 vision improving to 6/6. Now can you say it was absolutely necessary to perform cataract surgery? I'm just telling you. Then another thing they will tell you is, what is cataract? Then you will say lens will become thick, hard, like that. Okay. Then they will tell you, do you know the normal thickness of the lens? And you don't know, no, it is 2 millimeter, 3 millimeter, because it's all theory, it is not at all relevant. Then the lawyer will say, you don't know even the thickness of the lens. Then how can you diagnose cataract? I mean, that is a very useless question, but the judge will think that, you see, this doctor has absolutely no knowledge. To one doctor, they even ask how many bones are there in the body, suddenly. So the ophthalmologist doesn't know how many bones are there in the body, no? So he said, I don't know. See, this doctor doesn't even know how many bones are there in the body. And this doctor is operating on the patient. So these are, and they will talk about protocols, like, did you put povidone iodine in the eye? Then they said, did you promise that after surgery you can go driving home? Like that. Yes, and you drove. When you drive home, dust will go inside the eye, Now because of that, did you advise patch after surgery? No, I didn't advise, because normal cat doesn't need a patch. So you know what will happen if you don't put a patch? Dust can. If dust goes in, can they have infection? Yes, you didn't put a patch, that is why this has happened. So see, all these things, will come, the obvious things which you cannot even explain, these things will all rise up, and these are all questions which you cannot answer. So the whole take-home message is, loose talk by medical professionals is the main cause of litigation. So at least in our profession, if you look at lawyers, if one lawyer has a problem, everybody will jump into it and corner that fellow who's giving a case, and they'll finish him off. So in these things also, at least medical professionals should stand united for good things. I'm not saying that if a doctor is negligent, totally negligent, you should support him. But at least you should be reasonable, and you should not backbite another doctor. Then especially doctors who are relatives of the patient, who try to show them that, they will reveal everything to their relative and say that this is what has happened, etc., etc. And follow established protocols, document everything, take proper consent, video consent if necessary. And once you get a case, it is very important that the lawyer doesn't know anything. It is your case. You have to go behind the lawyer. You have to run your own case. And it's not like a doctor where you have the full responsibility of the patient. Lawyers have no responsibility towards you. And only 2 minutes before the case, they will look at your paper only. You will feel that they have been looking at your paper for all the time. They are reading your case only. It is not like that. And always be a part of professional protection schemes so that you're protected. Thank you.
Thank you, Dr. Ashok, for giving all those tips and with examples. I think it was a very good revelation of how and where and when you can go wrong and how you can protect your